review the status of the case. This has already been put on the record, but I'm going to do it again. Saturday, one of the jurors contacted the court deputy to report that he had been feeling poorly and took a home test, came back positive for COVID. He then did a PCR test, also came back positive. As of today, he has reported that he's got some symptoms, but he's willing to participate. And so he will be here tomorrow. We had two other jurors that tested positive, but are asymptomatic, I think we were informed. Is that right, Lieutenant?
Yes, sir.
Okay. They're willing to come in. So tomorrow at 8:30. So we have a full panel. We have all 8 jurors, 2 alternates and 6 regular, willing to participate. I have informed the court staff to come masked in tomorrow. I think that's a prudent thing to do given the circumstances that we have. Two jurors, maybe 3, who are potentially carrying the COVID virus. But I think we could get around that with the masking and ask the public also to do that when they enter the courtroom. So at the close of testimony on Friday, defendant had moved for directed verdict on all 4 counts. Over the weekend, I had an opportunity to do research and to look into the legal arguments and the case law supporting or opposing the positions. And I have prepared a written order, which I don't normally do, but since I had the time, I thought that would be helpful to avoid any misunderstandings. I'm going to hand that out in just a moment. I've got another handout for you, and that's relating to the instructions that I give after the close of evidence, before the closing arguments. As I've told you, I don't give the instructions until after your closing, although I do allow you to refer to the approved instructions during the course of your closing arguments. So you have that option. Then I've also got a proposed, and it's only a proposed, form for verdict as to count 1, and I'm going to hand that out to you. Again, this is just a draft. We'll work through these issues in more detail later. What I'm going to do is hand out to you the order on the directed verdict. I'm going to hand the original to the clerk for filing, and then because this affects the work we're going to do this morning on the jury instructions, I want you to take a chance, an opportunity here to digest what I've ruled, and we'll try to factor that into our discussion on the jury instructions in just a few minutes. So I'm going to take about a 20-minute break, give you a chance to look at this, maybe discuss it amongst yourselves, and I'll come back in and we'll start with the instructions. I've got the notebook Mr. Kessler, you provided on the jury instructions, and also the proposed verdicts. This verdict form I'm giving you is just something for us to work on and trying to get an agreement as to how the format should work with the questions that we have to give. So, with that, I'm going to hand this to Jovan. He's going to pass them out, and I'll see you back at about, let's make it 10:30, okay? Stand in recess.
All rise. Court's in a brief recess.
This goes to him too. Just to summarize, I granted the defense motion as to count 4, the trespass to personal property. I reserved on count 1 the intentional infliction of emotional distress. Mr. Kessler, at the close of the entire evidence, and also in the event of an unfavorable verdict, you may renew your objections. I'll do a de novo analysis of the entire case, so I'll allow you that option, which I'm sure you're going to do anyway. The jury instructions. Let me ask Mr. Timpanic, do you have any submissions that you'd like to present alternative to what Mr. Kessler's offered on the jury instructions?
No, Your Honor.
Okay.
Wasn't I there the day we were discussing the jury instructions?
We were, and you didn't seem to have any then, but I didn't.
I don't, Your Honor.
know if that's changed. Mr. Kessler, let's do it this way. Do you have his set? Mr. Timpanic, do you have his in front of you?
I could potentially find it, but not in front of me at the moment, Your Honor.
My thought is to go through, starting at the beginning, and you're going to call him up.
Well, yeah, what I can do, Your Honor, is if you turn on the screen here, I'll actually just plug in my computer and we can all have them right in front of us.
Okay. We're still at the left table?
Yes, yep, left table.
Well, front table. Does that work?
Yep, it did, Your Honor.
Okay, here we go. Well, you put the entire set from the beginning on. Let me help you with that. I think you can jump to the summary, which starts on page 23.
Okay.
I would suggest a cover sheet that just has the style of the case and the case number, and a statement that this is the jury instructions as approved by the court. Okay, that will accompany that. I request, let's see, we got 8 jurors. We got 3 counsel, we got the court. When we get to a final draft, Ms. Johnson, are you working this, or is that going to be Mr. Kessler? Who's doing the editing?
He is right now.
Okay. I'm going to require 1 original set, 15 copies. The copies will all be stapled. The verdict form, once we arrive at a verdict form, I will hold the original, and even though the jury will have a copy of the verdict attached to their instructions, the original, which I mark with the highlighter on the word verdict, will be the original one that I asked to be returned. And by the way, we're doing 1 form verdict with a series of questions, and we're going to identify each by count number, count 1, 2, and 3. All right? So the jury will know when we refer to that which ones it's applicable to. So, and on the jurors' copies, they can all be stapled, including the verdict form. The original verdict I'll keep and hand that to them with instructions. This is the one I want to have returned. Okay. Let's turn to the... Oh, I forgot to summarize. So we got count 4's out. Count 1 I reserved on. Counts 2 and 3, the assault and negligence, are still in, subject to other issues that we may address later, but for the moment, the jury is going to have a chance to consider counts 1, 2, and 3. Let's turn to the summary of on page 23. Mr. Timpanic, you were okay with this before?
Yes.
Okay. negligence, again, you're all right with the count 2 instruction summary. Is that correct?
Yes, Your Honor.
Count 3 is a little different because of the evidence that we had. Now, it was pled in the complaint that Mr. Deaterly aimed and fired the firearm at Mr. Jacobson. That was not the evidence. However, there is sufficient evidence for it to go to the jury on a different theory of assault. And the evidence there was that the two parties were in proximity to one another when the firearm was discharged. Mr. Jacobson did not know that there was even a firearm involved until the firing occurred. At that point, he claims that the defendant brandished the firearm at him, and as he made an effort to retrieve the dog, he was in fear of immediate harm. As you know, on a motion for directed verdict, I have to take all inferences favorable to the plaintiff, and indulging that, I have to allow that in evidence. The question is, how should the assault now be structured? And I've got a proposal, and it's only a proposal for us to work on. And let me ask Jovan if you could put this out.
Sir?
Take a look at it. It says, and again, I'm open to suggestions. I'm not determining this to be given, but just to discuss it. The assault instruction would read, quote, Rodney Jacobson asserts that Deaterly assaulted him by willfully discharging his firearm while in close proximity and by maliciously brandishing it with the intent to put Mr. Jacobson in apprehension of immediate harmful contact, and that Mr. Jacobson was put in apprehension. That's just for discussion. Mr. Kessler?
Regarding the some of the, and I just want to put something on the record, Your Honor.
Sure.
Obviously, the court has acknowledged that the evidence that it's taking in light most favorable to the plaintiff obviously wasn't something that was pled in the
Correct.
complaint. Obviously, we object to the proceeding with that because it wasn't anything that we were put on notice to as to the beginning of this case. Granted that that is the plaintiff's testimony now. It changed versus what he pled. So I just want to make sure that that objection is preserved on the record.
It is now, but there was no contemporaneous objection to the introduction of contrary evidence that contradicted the pleading at the time.
But the brandishing of the weapon could have been used for the other counts that are still valid here. For example, the intentional infliction of emotional distress in that.
Right,
and the negligence as well.
when there's a variance between the pleading and the offer of proof at trial, if it comes in without an objection as to that particular count, I think I got to allow it here. So I understand. You preserve your objection. Okay.
Thank you, Your Honor. With regard to the court's suggested language, I don't see any issue with it.
How about you?
No, Your Honor, that's exactly what I would have written.
No, that's comforting. All right, so do you want to, this is going to have effect in two places, on the summary of the assault and on the verdict form. We'll get to the verdict form, but hold that draft because it'll be incorporated in some form in the verdict. All right, so that gets us to the negligence claim. Mr. Tepanek, I've got a question for you on that. Oh, before we go there, I'm showing the next is on page 33, the greater weight of the evidence. Don't we repeat this every time on the counts?
Your Honor, truthfully, I don't see the need for doing that because we're already, it looks like 42 pages. That jury charge is going to be, well, easily the longest I'd ever experienced. So greater weight of the evidence doesn't need to be repeated every single time we do that.
I think in each count, there's a reference to the burden of proof. Correct me if I'm wrong, but it doesn't make sense to have a separate one on page 33. That's just my reading of it. Are y'all okay? We'll not have 409.3 given at that.
I agree with that, Your Honor.
All right. Next, let's look at page 34, which is 601.1. This is reference to the standard jury instructions. I'm suggesting, and again, it's just a suggestion, I'm suggesting that we modify it as follows, and I'll read it slowly. In deciding this case, it is your duty as jurors to answer certain questions on the verdict form. You must come to a unanimous agreement about your verdict. That would be the first paragraph.
With the, after the first change in the first sentence, Your Honor, are we leaving and you must come to an agreement about your verdict? Or what your answers will be?
You must come to a unanimous agreement about your verdict. The rest of this, you know, these instructions, frankly, I think insult the intelligence of jurors. They're so simplistic that we got a sophisticated jury here. We don't need to go down to the elementary school level. So I'm going to suggest that change just to make it simpler and more easily understood.
I have no problem with that, Your Honor.
No issue, Your Honor. I thought the same thing.
Okay. Do you want me to repeat it, or you got it?
Nope, I have it, Your Honor, and it should be on the screen in front of you, too.
Yeah, looks good. Now the next paragraph, the evidence in this case consists of the sworn testimony of the witnesses, all exhibits received in evidence, and all facts that were admitted or agreed to by the parties, and all facts, and any fact which the court has taken judicial notice. I think I did some interrogatory, didn't I?
You did, Your Honor.
Well, how about facts? Did we stipulate any facts that were admitted?
We did not ahead of time, Your Honor, no.
So we can strike that part. So it would read, the evidence in this case consists of the sworn testimony of the witnesses, all exhibits received in evidence, and any fact of which the court has taken judicial notice. Do you want to make a reference to the interrogatory?
Well, that and the existence of the, Sure, Your Honor. There's actually going to be two that the court took judicial notice of.
Well, the way we can do that is I can say that the court took judicial notice of, and then insert whatever it was I took judicial notice of.
That'll be fine with me, Your Honor. I want to reference back to the order in which you took judicial notice. And it's an order that's dated January 28, 2020, in which the court took judicial notice of the 8.6 mile distance shown on the map.
Do you want to reference it also by exhibit number since they're all in?
That is correct. We can't, Your Honor.
So just a brief description. It's a map admitted as exhibit X, whatever it is. So see what you can work with that.
those would be the two, Your Honor.
I think it should be filed with the clerk or the court.
Okay.
Let me send you this. How's that look, Mr. Companion?
It looks good, Your Honor.
Okay, let's go to page 35. The only changes I thought might help on this is on B. If we have it read, you have heard opinion testimony on certain technical subjects from persons referred to as expert witnesses. And then take out the brackets on the rest of that paragraph. Does that work?
That works for me, Your Honor.
Okay. They gave us several options that didn't really apply. And if you go down to paragraph C, where it says the witness should not be discredited just because the witness talked with a lawyer about, let's make it his or her testimony. Eliminate the brackets. Great. Okay. Let's go to page 36. We need to have it read, in your deliberations you will consider and decide 3 distinct claims and eliminate number 4. Okay. Any other proposed changes on that paragraph or that page?
Not for me, Your Honor.
All right. You can strike the next one, page 37, because it anticipates the instructions given prior to closing. So we'll just eliminate 601.5. Okay, we're now on page 38, which is closing instructions. I'm suggesting that the first paragraph read, members of the jury, you have now heard all the evidence, my instructions on the law, and the closing arguments of the attorneys, eliminating that you must apply in reaching your verdict. I don't think it's necessary. Okay. The next change is the next paragraph. And I just don't see the need to have, if you happen to pass by the scene, do not stop or investigate. This is usually used for personal injury cases, accidents, and that sort of thing, so don't think we need that. The third paragraph, do we really need to suggest that they not contact a family accountant, doctor, or lawyer? I'm suggesting a period after do not contact anyone to assist you, period.
I'm fine with that, Your Honor.
Okay, the rest of it looks like pretty standard. Turn to page 39, continuing with that instruction. The third paragraph from the bottom that starts, I will give you, should read, I will give you a verdict form with questions you must answer. Period. Yeah. And the last sentence in that paragraph that says, I will now read the forms to you, you can strike that whole sentence. I will make a statement, and we will review the verdict forms in detail at that point, but there's no need for that to be in the instruction. Jovan, I just want to check the procedure that we have here. We typically station a bailiff outside the jury room and they knock. Is that how you do it here?
Yes, sir, absolutely. That'd be myself.
Okay. And the 8014 on page 41, strike that entire, I have my own little closing colloquy I do on this. Mr. Kessler, if you could, when we're doing the summary, if you could, I'm going back to page 26 now. I'll make it 23.
Yeah.
If you could, before we say summary of intentional infliction of emotional distress, above that, write count 1. Perfect. And then follow through with the other counts, same format. Page 26 and page 29. Mr. Timpanic, are you going to be asking for psychic damages in the negligence count and or the assault count? Or is it just in count 1, the emotional distress?
I think it's, Your Honor, just going to be in count 1 and the emotional distress.
Okay. So,
but that's obviously not final yet, but that's what...
well, we need to know because we're doing the instructions.
Okay, yes, Your Honor.
Okay.
Your Honor, should we put a statement under count 2 and 3 under the damages section that the jury is not to consider emotional damages for these particular counts?
Well, that's the plaintiff's position.
Actually, Your Honor, I think I think we are just going to do it for all 3 counts. Thinking about it further.
How do the damages differ? If you get a verdict on the emotional distress, wouldn't that subsume any mental distress in counts either 2 or 3? I mean, how's it different?
Well, I think potentially, Your Honor, the jury might differentiate between the counts. Okay, psychic damage, we don't find in favor of the plaintiff as to the intentional infliction of emotional distress. But we do find for him in the negligence count by taking out that language to be like, okay, well, that potentially limits the damages. I think that since they're separate counts, Your Honor, it's, to me, it's not if they fine for an intentional infliction or don't fine for it, that doesn't necessarily mean they're not going to fine for it in the negligence or the assault count. That's just my worry.
Well, let's just play it forward hypothetically. Let's assume that they render a verdict on the emotional distress and put in a figure, pick out a figure, and then in the negligence or assault, they also come up with a figure. Substantively, really, how does that differ from what they arrived at in the in count one?
My thinking, Your Honor, as you can understand, the difference being is that's assuming they fine for all three counts. They could find emotion, if we limit them to each and every count, they could easily fine against, they could, hypothetically speaking, say, when asked if defendant was acting in self-defense, answer no, and then move on to the IIED claim and don't find the claim doesn't rise to that answer no, but then fine for negligence and assault. And if we don't put them there, then they wouldn't be able to consider psychiatric damages, because a split verdict is entirely possible here, and I don't want to pigeonhole the jury or conventionally confuse them.
No, I understand your position on that. My question is, assume you get a verdict on psychic damage on all three counts.
Mm-hmm.
How is that going to be, how can you separate, I mean, if your clients have suffered psychic distress in count 2 and 3 and also in 1, what distinguishes it if that result should obtain?
Potentially, Your Honor, I don't know, we could ask them, do we find psychic damages, and then put it on the verdict form so they can be able to if you're worried about them not being able to differentiate, it might be in a position where we could put it on the verdict form to allow them to actually state whether or not. But, Your Honor, as you can understand, this is...
Well, we're asking them to, if they rule in your favor,
yes,
they're asking them to state a dollar amount in each count for the psychic damages. And I'm just asking the question, if they deliver it in count 1, how is it different from... I'm having a problem with, I'm just telling you right now, it may not happen, it may not be an issue we have to worry about, but Mr. Kessler, anything you want to add?
I can understand the court's concern that he might be trying to triple recover for emotional damages in the event they were to come back all three and assess emotional damages on each 3 counts. Really should have only been assessed once overall for the emotional damage. So I see and understand the court's position on this.
Well, let's just say that we can't resolve it today, I don't think, but it's just a question that struck me as being a potential issue later down the road. The other thing is, Mr. Timpanik, you indicated that you were not seeking any future damages.
No, Your Honor.
Okay.
So I'll put that in the instructions then, Your Honor.
Well, let's see what that, are you going to put that in each count?
Yes, Your Honor.
And what are you suggesting as far as language goes for that?
Mr. Jacobson is not seeking damages for any future
Pain and suffering?
emotional distress and pain and suffering. So
You can use mental anguish also. That's a synonym for it.
emotional distress and pain and suffering. And mental anguish. So you would only consider an amount of damages from the time of the incident November 18th, 2016.
To date?
Yeah, to date.
Let's do this. Put a period after anguish and start a new sentence. You were only to consider. Does that look good, Mr. Stefanik?
Yes, Your Honor.
Okay. And you're going to insert that in each count?
I am. I'm going to do that right now, Your Honor.
Oh. I'll let you get that. I got one additional remark.
Ms. Johnson and I may have come up with a mechanism to alleviate the court's concern on the verdict form, but I'll let you go first, Your Honor, and we can circle back to that.
Page 29,
Okay.
down at the bottom, impact rule. Needs to be deleted.
Yeah,
Is that page 29?
Was my page 29.
it's already out, Your Honor.
It may have changed. Could you do a word search for impact?
Yep.
Just to be careful. I've determined that to be a legal issue, not a jury one.
Yeah, there's the impact rule right there. I think it said there was another one too that had 2 results. Could be wrong. Yeah.
That's it for the impact rule. All the references have been deleted, Your Honor.
Okay. Are we good with the instructions so far?
Yes, Your Honor.
Mr. Kessler, you okay?
Yes, Your Honor.
All right, let's talk about the verdict. So, I think we talked pre-trial about having the threshold question being on self-defense, and that if they find self-defense, that would be a judgment as to all 3 counts. Is that where we're still there?
I am, Your Honor.
Yes, Your Honor.
Okay. So I've given you my draft. Again, I'm open to suggestions. It's just count 1 that I was able to do. Let's review it. So count 1 says, or the verdict says, oh, by the way, would you insert the style of the case before this so that it'll say Jacobson versus Deaterly case number and then go into the verdict?
So I have, Your Honor, before the preliminary question. I did not receive your proposed verdict as to count 1, Your Honor.
Oh. Do you have those? I thought I handed them out.
Oh, yeah.
I handed out the orders and the verdict form.
Do you have the verdict form?
I don't.
Was the verdict form the second thing I turned down?
We have the instructions at the close of evidence, the count 3, a summary of claim, and then the order on the motions for directed verdict.
I thought I gave you that. No, you're correct. Here. they're similar, but I kind of made it, I like to have them concise as possible without sacrificing any confusion, so I don't want to encourage confusion. So my verdict reads, this is as to count one. It should say verdict, and then count one is down below. So the jury shall answer the following questions. Was Deaterly justified in using deadly force against Candy in self-defense? If your answer is yes, your verdict is for Deaterly on all counts. No further questions are to be answered. Sign and date the verdict and return to the courtroom. If your answer is no, proceed to question one.
Can we just, to make it more concise, can we leave it as it's phrased here in the verdict form, number one being the preliminary question, and then proceed to question two, or do you want?
No, I think we need to renumber it.
Okay.
I think the preliminary question does not need to be numbered.
And Your Honor, we like the language you have on the verdict form. We'd just be asking to change that. Instead, just read was Mr. Deaterly justified in using deadly force against Candy in self-defense?
Yeah. I mean,
Right now it says that against the dog.
They know it's a dog, so yeah. So it'll be a question mark after self-defense.
We're going to object on the use of the dog's actual name on the verdict form, Your Honor, only because it leads could lead the jury to have the impression that Candy is something more than just a dog, even though we're well aware that it's not, but I don't want that impression to be given to the jury. I'm fine with saying, was Mr. Deaterly justified in using deadly force against the dog in self-defense?
Okay. That's fine.
Your Honor, I would just say we'd be asking the name be put in. It was on the verdict form you provided us, so I'm just asking for that.
All right. We're going to use dog, not the dog's name.
Is it fair to say Mr. Jacobson's dog?
There's no other. I think we're quibbling over really something that's not that significant. We'll keep dog in there and keep it simple. Now, as to count, you'll need to change, if you put the capital Q in front of each question, because we refer to it, that's a pattern I've used in prior ones. It seems to be helpful. Well, this may be difficult to do with the editing, but looking at my draft, count one says, as to the claim of intentional infliction of emotional distress, question one, was Deaterly's conduct toward Jacobson deliberate or reckless, yes or no? If you answer no, your verdict is for Deaterly on count one. No further questions are to be answered in respect to count one. Go to count two. If you answered, go to count two. If you answered yes, proceed to count two. I think we need to strike go to count two, right? If your answer is no, your verdict is for Deaterly on count one. No further questions are to be answered in regard to count one. If you answered yes, proceed to question two. Does that make sense? I'm asking you to make your changes. I don't know if you can do it fast enough or not for this, but we can work off, my draft.
So if I understand,
if you answer no, your verdict is for Deaterly on count one.
Yep.
No further questions are to be answered in respect to count one. If you answered yes, go to question two. Does that work?
Yes, Your Honor.
Okay. Question 2 is, did Jacobson suffer extreme emotional distress of such intensity or duration that no ordinary person could be expected to endure? Yes or no? If your answer is no, your verdict is for Deaterly on count 1. No further questions are to be answered in regard to count 1. And also strike what I've written and go to count 2. If you answered yes, proceed to question 3. Let me ask this question, and maybe I need to go back. Let's go to question 1. If your answer is no, your verdict is for Deaterly on count 1. No further questions are to be answered in respect to count 1.
Shouldn't there be direction, Your Honor, that in the event that they, if their answer to question 1 is no, directing them to answer the next question that would be applicable?
I think we need to say that if you answered no, you have decided for Deaterly on count 1, or something worse to that effect. We probably need to add that same language on questions 3 and 4, and striking go to count 2 in each of those.
So the first question, was Mr. Deaterly's conduct toward Mr. Jacobson deliberate or reckless? Yes or no? If they answer yes, go to question 2. And for question 2, the court would like to use, yeah, I don't have any problem with that one.
Let's do this.
You had an issue with
Mr. Kessler,
Yes, Your Honor.
let's title this somewhere, draft 1. We'll print it out and look at it so we can study it that way, make sure everything's good.
Okay.
Natalie, you got the printer over there? Okay, yeah, print out 3 copies.
You want 3 copies of
This is, we'll call that draft 1.
Okay. I know. Would you like me to email it to you, Madam Clerk?
What's good for you, Natalie? Pardon? she's forbidden to take emails from outside. I know. So, I guess we can't do that.
I mean, I have no problem leaving it up here, Your Honor, and us working through it one by one. I mean, I think that
Let's
that's...
go back up to the top. It's just a small thing, but we're using Roman numerals and mixing it up. It's not a biggie, but that's what you presented before, right? Any change in that one, Mr. Kessler?
So my only suggestion, Your Honor, would be on the first sentence stating, did Mr. Jacobson suffer severe emotional distress as a result of Mr. Deaterly's conduct?
Your Honor, what defense counsel had previously and what you have is what we would prefer to say. That's starting to get a little confusing. I think that's the question's already been answered, so it's kind of redundant. And we're at the point where Mr. Deaterly's conduct a legal cause of Mr. Jacobson's severe emotional distress. What you have here and what they previously had was what we'd be asking for. This is starting to confuse me, and what I can tell you, it would likely confuse the jury as well.
What was, if I may ask, Your Honor, what was the court's apprehension with using the verdict form as the count one that was previously agreed to by all parties?
I don't think it was as clear as it could be.
And the question through that the court has proffered, Your Honor, obviously Zach's conduct has to be the legal cause of the emotional distress as a causation factor. That's clear under the Hyung Chain case.
Well, but my instruction includes that.
It includes it, but then it goes on to say produced or contributed substantially to producing, and while it may contribute to it, it doesn't necessarily imply the cause. So it has to be the cause, so versus a substantial contribution.
I was going to say, what is on here that was provided is, I think, in my opinion, clear was obviously we'll say Mr. Deaterly's conduct a legal cause of Mr. Jacobson's severe emotional distress, in that his behavior directly and in the natural consequence sequence produced or contributed significantly to producing emotional conditions so that it can be reasonably said, but for the extreme and outrageous conduct, Mr. Jacobson's severe emotional distress would not have occurred. That's as right on point as what we're looking for as a causation. Legal cause, but for all causation language and taking into the facts. So that's what we would be seeking to be put as the wording, just as it's exactly clear, if it were, Your Honor.
So, Your Honor, I will quote the Kim v. Jung, Jung, Hyun, Chang case 249, Southern 3rd, 1300, second DCA case from 2018, and I'm looking at specifically page 1306 of that opinion, Your Honor, and it states that there's two questions to answer. You have the elements of causation and severe emotional distress. The subjective question is whether the plaintiff in fact suffered emotional distress as a consequence of whatever the defendant did. And then the Kim case cites Elderwoods Group Incorporated versus Garcia, 119 Southern 3rd, 497, third DCA case from 2013. And it cites the holding in that case that the question of whether a defendant's conduct caused severe emotional distress was not amenable to class action treatment. But I think that the principle of these cases, Your Honor, is that the defendant has to actually have caused it, not that he substantially contributed to it. There has to be an actual causation factor to it. And the last paragraph, which is the holding of the Kim case, I'll quote for the record, it's at 1309 of the opinion. Because the evidence was not legally sufficient to prove that Mr. Kim's conduct caused Ms. Chang to suffer severe emotional distress, the trial court should have granted Mr. Kim's motion for a directed verdict on that counterclaim. Again, making a definitive bright line determination that you have to have the actual cause. His conduct has to be the cause of the severe emotional distress.
We have a standard instruction in the jury instructions on it. If you'll look at, I don't know if you have access or not, but it's 410.4. And the language that I took is from 410.6. And I'll read this to you. Again, these are standard instructions given in cases involving extreme or outrageous conduct. It reads, I'm looking at A, legal cause generally. Extreme and outrageous conduct is a legal cause of severe emotional distress if it directly and in natural and continuous sequence produces or contributes substantially producing such severe emotional distress, so that it can reasonably be said that but for the extreme and outrageous conduct, the severe emotional stress would not have occurred. And then, I mean, that's what the standard is, and that's what I think I tracked.
And I think where your language differs from the standard instruction in 410.6, Your Honor, and I think that this would be a distinguishing notation, is that under the 410.6 instruction, legal cause generally states extreme and outrageous conduct is a legal cause of severe emotional distress if it directly in a natural and continuous sequence produces or contributes substantially to producing such severe emotional distress versus your proposed language which says to producing the emotional condition. So I would just ask that...
Are you okay with the standard?
Your Honor, in citing the controlling authority from Kim, I would have to place my objection on the record to using the standard instruction and adhere to the strict causation language as referenced in the holding of Kim, understanding that it might be, the objection may be overruled, but I want to preserve that for the record.
I think we have to go to standard. I don't see any factual basis to distinguish. So your objection is noted.
So we'll be incorporating the standard instruction under 410.6, the legal cause generally, Your Honor?
That's correct. It'll just, you don't put legal cause generally. You just start out with extreme and outrageous conduct. I'll give you a chance to insert that. I think we have to put it in the form of a question.
Correct, Your Honor, and I'm going to be amending it on the screen.
Mr. Paddock, you okay with the standard?
Yes, Your Honor. Standard instruction is fine.
Let me point out that this language is incorporated in the summary of the claim on page 23 as we're including in the verdict. It's consistent.
And we're on now on to your proposed question number 4, Your Honor. And I have no problem with question number 4.
Okay, how about the instructions afterwards?
No issue with what you wrote, Your Honor, on your verdict form. Was Deaterly's conduct so severe, outrageous, and so extreme in degree that went beyond all possible bounds of decency, so as shocking, atrocious, and utterly intolerable in a civilized society? That's fine, Your Honor.
I guess this is where our suggestion would.
Wait a minute, you've got
sorry.
count one. You mean, yeah, but it says, count five, you got 6 there, so I'm sure you're going to change that. So,
You mean the question number, Your Honor?
yeah.
Yeah, I'm gonna address that. But at first, what I wanted to do is question number 5 on your proposed verdict form is what is the total amount of Jacobson's damages attributable to the severe emotional distress? So what Ms. Johnson and I had discussed and what we'd like to propose to the court is separate the damages aspect for IIED. So obviously we have compensatory damages, and then I think emotional damages are not, I don't know if I would characterize them as being included in the compensatory, perhaps.
You want to separate, well, let me just ask Mr. Timpani, aside from the emotional distress damages, what else are you asking for?
It's just, with punitive damages out, it'd just be the compensatory and the emotional damages.
So there, Mr. Kessler, as I understand it, he's seeking only emotional damages.
So what I would suggest to the court is that way we don't result in the issue of where the jury is assessing emotional damages under 3 counts, essentially allowing him to triple recovery for the emotional damages, is that we have one emotional damages question at the end of the verdict form for the jury to answer. So for example, my suggestion would be that as here, if your answer to question 4 is no, you have decided for Mr. Deaterly as to count 1. No furthers are to be answered with respect to count 1.
You don't want them to answer the question of what emotional damages they want to award for distress in count 1. You want it to be at the end, having considered all the counts.
That's correct, Your Honor. So I would just refer them, instead of saying please answer question 5, we would say please answer question whatever it happens to be at the end.
Mr. Timpani.
No, I'm supposed to say no, but that would make it much easier for the jury to decide what they have for emotional damages. They just add them up. What we could do is just add an instruction and, just allow them to say what they're going to do for the counts they do fine for. I think that'd make it easier. And we wouldn't be left wondering whether they found emotional damages for this, but not for that.
I don't know how to phrase that, though, in the verdict, to avoid any confusion. I'll tell you what, let's take 10 minutes, see if you can come up with some language that would work. It's kind of hard to do it on the fly, but I'll give you a chance to work on it. Come back and see if you arrived at something, all right?
Thank you.
All rise. We're in a 10-minute recess.
have any luck?
Yeah, we're almost there, Your Honor. Just a couple other changes that we need to make, that's all.
What's each count to start on page 2?
Yeah. So what's the next question after that?
I'm going to step out for just a minute.
That's good. Please answer question.
So then,
We'll have a new page
there
for
was
this.
assault, but then it should go up. Please answer, okay, so the continuation, please answer 12, go down. Please answer. If you answer, okay, so that's the last question. If you answer the question 12, yeah. No, I don't think that's it, because that might seem to limit it to assault. Yeah, so like that.
And then if you found on either count 1, count 2, or count 3, please answer the following question.
I think that's the way to do it. You agree, Matt?
Looks good.
Okay.
All right, be seated.
I think we have an agreement as to the form, Your Honor. We just want to run through it with you to make sure that you're comfortable with it as well.
Johan,
Yes, sir.
this is the email address for the judicial assistant.
Okay.
For printing out anything, she's agreed to do that. I tell you what would help me, if you could send her this so I could look at the entirety of the instruction or the verdict form to get an idea what you're doing. Let me know when it's sent, and I'm going to retire and look at it in chambers.
I just sent it, Your Honor.
Okay, I'll let you know after I reviewed it. Kind of give me a heads up what we're doing, what you all agreed on.
Actually, it wasn't sent yet because I'm not connected to the internet, but it will be sent as soon as I connect to the internet. It was sent, Your Honor.
Okay, so give me kind of heads up, what are you doing?
Oh, we agreed on the form that you're going to be reviewing, Your Honor.
No, I mean, what did you do in regards to the psychic damages?
So what we've done is we've structured it in a way where they're going to either find for or against Mr. Deaterly for each count, and then in a similar manner to what we did with the self-defense, we have a separate question at the end of the verdict form pertaining to damages, and it says specifically if you have found against Mr. Deaterly and for Mr. Jacobson, as to either count 1, count 2, or count 3, what are Mr. Jacobson's emotional damages?
And you've agreed to that?
I thought it just said damages.
Or maybe damages, I'm sorry.
Yes, as to just damages, Your Honor. So we're not like differentiating. So they're not trying to figure out what and which. It's like, did you fine for them? Okay, what are the damages? And
Okay, so if they bring back a verdict for damages, you're not going to be able to discern which count it applies to.
That's
right?
correct, Your Honor.
that's correct, Your Honor.
Okay, and you're willing to, both sides willing to accept that? You okay with it, Mr.?
I am, Your Honor. It'd be obviously way too confusing otherwise.
More than one count anyway, should be.
Because then, Your Honor.
So the only thing I want to do, Your Honor, is confirm with Mr. Timpanic that with regard to the comparative negligence, for negligence, if the jury finds that Mr. Jacobson was comparatively negligent, that percentage would be reduced with the overall damages figure.
That's interesting. Because then it'd be, but by doing so, they're essentially fine, because is comparative negligence for all 3 counts the defenses?
Just the negligence count.
That's a problem, because then it could be, Your Honor, thinking being is, then it would, if there is intentional infliction of emotional distress.
You shouldn't have comparative negligence reduce a verdict either on assault or on the IED.
Correct.
So, and it's structured in such a way where the comparative fault will only be triggered in the event the damages are awarded for negligence. And the emotional damages, whether he's prevailing on count 1, count 2, or count 3, or all 3, are going to be the same, or in theory should be the same. For example, it would be an inconsistent verdict if a jury came back and awarded $1,000 in damages for IIED, but then came back and awarded $2,000 damages for assault when the measure of damages and the damages themselves were the same and consistent through all 3 counts.
Well, would you then, okay, you're making the assumption that the damage claim applies to all 3 counts. So judgment would be entered for the IED in the full amount, negligence, comparative negligence reduced by whatever percentage they give, and then the full amount for the assault?
Absolutely not, Your Honor. So that would be a triple recovery, which I don't think that the law permits, because he'd be recovering emotional damages for IED, assault, and negligence when it's only one. I mean, he can't recover triple for one damage.
I agree with that, but how do you meet his objection that you shouldn't reduce comparative negligence or apply comparative negligence to counts 1 and 3?
So we address that because if the jury comes back and finds in favor of Mr. Deaterly as to count 2, it's a non-issue because there is no comparative negligence. If the jury comes back and finds in favor of Mr. Jacobson as to counts 1 and 2, right, the measure of damage is going to be the same. And if damages are going to be reduced under the comparative negligence theory, I mean, they should be reduced.
I don't see how I could go forward with that without the defense stipulation. He's going to have to agree to the form of that because it's an unusual approach.
So we're going to have to remodify the...
That's the problem with having it, one damages for applied to all 3 without discrete determination.
Your Honor, I thought of during the break, I did think of an alternative solution. The thinking being with that is my fear is if they just add them all together, then we'd be in a position, like I said, to reduce the whole award based on the comparative negligence count, which doesn't apply. A part of me thinks there should be questions asked at the end of each section.
Go ahead.
How much each section, say, at the end of the IIED section, $1,000, negligence, $1,000, and assault, $1,000, just for argument's sake. And from there, it's the jury is asked, okay, was this just you were just doing a flat amount throughout, or are you saying this is what his damages are for this, plus this is what their damages are for negligence, and plus what is it for assault? Because, so we can ascertain, give them the information, and they make the determination for the fact finder. And then from there, we would be able to, okay, they apportion 20% to Mr. Jacobson, and as such, that negligence count is reduced by $200.
You know, I don't know how we can overcome the objection on the comparative negligence. So, Mr. Kessler, we're going to have to revert to the standard. Going to have to give him damages. Now, I understand the question about double recovery, but that's a legal issue that I could address after the verdict comes in. So I just don't see any way around it. I'd like to accommodate you, but I'm afraid it's way too complex to hammer something out today, particularly in light of the defense's objection.
So the set that you're getting will not be the final, then, Your Honor.
Right.
And I guess what we're doing is we're going to re-implement the damages question for each
I don't see
count.
any way around it. I like what you're trying to do, but it really raises a legal issue about status conference about how you can distinguish emotional distress damages from mental anguish in the other two counts. I'm working on that. I just haven't come up with a solution, but it's squarely an issue. But it may not happen. We just, we've got to be ready for it in case it does. So why don't you work on that revision, and I'll step out again and come back, say at 1:15.
All rise. Court's in recess.